Development in EU Financial Services Law, Legal Yardsticks, Judicial Scrutiny and Charting the Way Ahead. And I will again ask our moderator, SRB Board Member Tuija Taos, to introduce our distinguished panel. Tuija, please.
All right, good afternoon, good morning, everyone. It's not yet afternoon, it's morning. Yeah, it's a great pleasure for me to welcome you all to this second panel, on which we will now focus on enforcement in the EU financial services law. Well, this is indeed a very central topic, ensuring the integrity and trust in our EU financial market. And as we all know, effective enforcement is a cornerstone of each and every regulatory system. However, in the financial services sector, the enforcement seems to be a quite complex topic, especially because it's shaped by the evolving legal landscape, but also because it's challenged all the time by the developments in the market and technology. So in today's discussion, we will try to navigate through these critical dimensions, and we will examine the current legal standards and practices, but also the role and the scope of judicial review in enforcement actions. And we are very lucky to be joined by an esteemed panel of experts who will bring us diverse and complementary viewpoints on this topic. So let me now briefly introduce our speakers. I start here. Welcome Silvia Allegrezza. You are the Associate Professor of Criminal Law and Procedure at the University of Luxembourg. Welcome. And then next one, Miro Prek. You are now the Chair of the Board of Appeal at the European Union Agency for the Cooperation of Energy Regulators. And prior to that, you served as a judge at the General Court of European Union, and you were there twice elected as President of Chamber.
Thank you.
So, welcome. And then we have Amandine Zelenko. And you are the head of the enforcement unit at the European Securities Market Authority, ESMA. Welcome, Amandine. And then Roberto Ugena. And you are the Deputy Director General in the Legal Services Directorate at the European Central Bank. So, welcome all. So, the structure of this panel will be similar to the first panel. So, I will let first all our four panelists to give us their pre-prepared presentations. And only after that, we will open the floor for questions and answers and discussion. So first, our first panelists, Silvia and Miro, they will set the scene with academic and jurisprudential perspectives. And then after Amandine and Roberto, you will provide us with your practical experience from ECP's and ESMA's enforcement experience. So I'm looking forward to a very rich session, and I'm sure it will be a great interest to not only to the audience, but also all of us who come from SRB, because SRB is also an agency which has entrusted with sanctioning powers. So, without further ado, I let you, Silvia, now to start, please.
Thank you so much, and thank you for this kind invitation. I am extremely honored to be here. A few words before I start with my presentation. As the chairwoman just said, I am a criminal lawyer with a specialization in criminal procedure, so I feel absolutely like a black sheep here in the room, and maybe I feel the need to justify my presence. Almost 10 years ago, together with esteemed colleagues, and many of them are actually in this room, I started an ample research project on the integration conflicts between different levels of enforcement. And in particular, the focus was how the administrative enforcement within the SSM, and in particular sanctioning powers, were interacting with the criminal enforcement that was running sometimes along the same paths as banking supervision. And I continued over the years to make research in these fields, and particularly very recently are more into how integrated enforcement has to be applied to the AMLA structure. And then I received this very kind invitation. I'm not an expert in banking resolution, but fortunately here my task is very limited in the sense that I am going to introduce the topic of punitive sanctions, mapping with a mapping exercise. I will adopt an integrated approach between the European Court of Human Rights on one hand and the Court of Justice and the Union action on the other hand. I will then start via the triptych of leading cases adopted by the ECHR throughout the years. We will then have a very quick look into the rise of punitive sanctions within the Union that literally exploded in the last 15 years. We will see how the dialogue between the ECHR and the EU is reshaping the field of punitive justice. And then I hope to have the time to focus on the intrasystemic effects of the punitive sanctions doctrine, and in particular its potential limits, because this is particularly relevant within the SRB, as I could even more understand in light of the presentations of this morning. I intend to focus on two aspects, nemo tenetur and the separation between investigation and decision-making process, with the intention to provocatively leave the floor to Miro Prek afterwards on the concept of unlimited jurisdiction. So in order to prepare my presentation today, I decided to go back to history. This is always a very useful exercise because it helps us to highlight what was the spirit and in particular what were the priorities at the time in which the European Court of Human Rights came out of the blue with this doctrine of punitive powers, indicating a sort of gray zone in between administrative and criminal enforcement. I think it's important because the more I hear you banking lawyers, experts in this field, the more I feel that we have to rethink the categories of the entire building. So from the very beginning and quickly, because I think this is shared knowledge here in the room, we have to go back to 76 with the first case, the Engel versus the Netherlands case of the ECHR. Why this is important? Not only because the very famous Engel's criteria were sketched in that decision, meaning in order to decide whether a sanction is punitive or non-punitive, and I'm using punitive or accoloration pénale in an interchangeable way, being aware of the nuances, but here for the purpose of this presentation. So the very famous Engel's criteria are three. First, we look at domestic definition. If it's criminal, it's enough. If it's not, we have to dig into the second and third criteria, meaning what is the nature of the offense and what is the severity, and later on, in the development of the case law, what is the nature also of the sanction. And what is important to mention is that everything started because in the Engel case, the issue at stake was liberty, personal liberty, because this was a disciplinary case in relation to military offenses. And the penalty that was applied to Engel as an administrative penalty was military detention. That is important because it highlights where everything started, protecting personal liberty. And then the doctrine detached itself completely from this very original kern, this very original core of what we have to consider as punitive. And this brings us to the Öztürk case of 84. Here, what is important is the political spirit of the time. Why? We are at the very outburst of depenalization that started in Germany but then contaminated other countries. So at the time, the intellectual and political then operation was to reduce the amount of criminal offenses, something that we should maybe go back to reducing criminal offenses. So this was the fruit of a very large political operation with a lot of political support in many countries of the contracting parties of the ECHR. So once that the case came up to the court, the political issues at stake were many and extremely relevant because the court didn't want to kill the depenalization operation because this was pivotal for many countries. So what they did was to work within the concept of nature of the offense. That is absolutely the most difficult one to define and honestly undefined of the three Engels criteria. But what is also interesting to notice is that first, the right at stake was a very easy one, right to interpretation, something that is completely irrelevant, for example, in all your fields. And the second one is that the court added an incidental and final remark in which it says, conventionally, criminal charges, that is the gray area we are all interested in, do not imply the general application of Article 6 guarantees. And even if it does, a full judicial review is enough to recover potential lacks in terms of fair trial rights we had in the previous stages of the case. So why it is important? Because for the first time after Engel, the Court of Strasbourg here says out and loud, the fact that we are within the criminal limb, within the criminal head of Article 6 ECHR, doesn't mean that we have to apply the panoply of procedural safeguards to the extent that they are applied in criminal law. And this has been confirmed, but as you can see, more than 20 years later, in the famous Jusila case, this was a TVA fraud in Finland. Rights at stake more relevant because it was the right to be heard and no public hearing held by the administrative within the administrative procedure. The court confirmed the autonomous notion of criminal matters. There is no sector-based application of the Engels criteria according to the relevance of the specific field, and this is something I think we should do reprocess somehow. Whereas there is a sort of hardcore of criminal law. So, hardcore of criminal law, full extent of procedural rights. Gray area, conventionally criminally charged, what we call punitive sanctions, not necessarily imply the full extension of application of procedural rights. So, we had first the affirmation of an autonomous concept, and this was maybe one of the most effective operations of the ECHR in affirming autonomous concepts, something then it was then taken on by the Court of Justice in different fields. The sketching of the three criteria with an increasing case law, then the indication that consequences are not necessarily that we are entirely criminalizing the administrative punitive field, but nobody was listing, and nor the court was precisely listing which rights, and in particular, to what extent these rights have to be applied. Let's move on the other side, because we need to integrate the union in our analysis. So we have, timely speaking, one time that was before the 70s, and then we have after the 70s, and honestly, I would say then we have after 2008, but that's maybe for the debate, for the question time. So before the 70s, the community law remained quite silent on the enforcement on new policies, and we had this was meant to be achieved via the duty of lawyer cooperation by the member states. And then we suddenly moved very, very quickly into the development of integrated enforcement, in which administrative sanctions intended as an enforcement tool were adopted in many, many areas of EU law. It was done via two strategies: negative integration, mobilizing the four freedoms, but this is not that much relevant here. And on the other hand, via positive integration, so by a legislative way, sector by sector approach, but with competition as the strongest blueprint. And this happened, as you know better than me, in many, many fields, from financial interest to banking supervision, to market manipulation, to banking resolution. And finally, we will have AMLA. So we are at a bit, maybe, I'm not even sure if we are at the end of the road. Anyway, the internal evolution of administrative sanctions, in particular after 2008, and this is, of course, this is the criminal lawyer speaking here. So what I can identify with specificities of the sanctioning system after the revolution due to the financial crisis, we have now more severe sanctions. We have including more and more individuals and legal entities, not that much relevant here, but in particular what we are doing, we spread out the turnover-based mechanism even beyond administrative law. If you're interested, I can tell you that the recent criminalization of breaching of economic sanctions is now adopting the turnover-based system even in criminal law, that it's a way to revolutionize the very concept of proportionality in criminal law. Not only that, what we had the creation of specialized agencies with autonomous, coercive, investigative powers, with lower standards when it comes to evidence, and with different types of limitation in terms of judicial review. So this is the current picture. The dialogue between the two courts happened via two main ways. The first one, we had the formal borrowing of the case law of DCHR. This has been done in very famous cases like Ackerberg-Franson, in Bonda, Inspector Photo, in DB versus Concept, just to start mentioning the Nemo Tenetur Sede Tegere. But we also had informal borrowing in all the fields in which certain procedural safeguards have sold the light progressively via the EU new legislative framework, in particular in the field of regulatory powers. So where do we stand, more or less, in our little history of punitive justice? For sure, we have the expansion of Article 6 via Article 6 of the treaty, Article 6 ECHR via Article 6 of the Treaty of the Union into Article 47 of the Charter. And this line is stronger and stronger. But on the other hand, we had an expansion that administrative and regulatory experts might be less aware of, that has been the adoption of the EU directives of the Stockholm Roadmap on the criminal law side. And some of them are also applicable to the administrative proceedings when certain conditions are met. So the outcome is an applicability à géométrie variable of procedural safeguards in their criminal limb, with two sorts of consequences. The first set of consequences we are not going to analyze because it's out of scope of this panel are the intersystemic consequences. So what are the consequences in relation to criminal enforcement? Because many of these fields, they also have a parallel criminal tier. Ne bis in idem is the main problematic issue. But what we are going to analyze today are the intrasystemic consequences of this major development in EU law. And in particular, we extended, and this is still a question mark, to what extent what has been established for individuals is also applicable to legal entities, because in your specific case, you're exclusively dealing with legal entities. So which ones, to what extent, is still an open question that I do not pretend at all to solve here, but at least to have an exchange with all of you. So we can identify two families of procedural safeguards, procedural issues that are related to fundamental rights of the individual or the legal entity, culpability, privilege against self-incrimination, duty to disclose incriminating documents, in particular, access to a lawyer, access to the file, right to be heard, public hearing, we can go on. But on the other hand, some of them are structural, meaning it's easy to provide, for example, the right to the interpreter. That it's quite easy. It's much more difficult in the regulatory framework to introduce safeguards that imply a structural change, like, for example, the separation between investigation and decision-making procedures. And this also implies somehow a debate that will then go on with Miro on the concept of unlimited full jurisdiction and judicial control, in particular before the Court of Justice. And it also implies externally the relationship with criminal in terms of nebis in idem. Very humbly, this is my separation on what is sufficiently protected and what is not sufficiently protected. And again, this is the criminal lawyer speaking, so we might have different perceptions on that. I would say that the blue part, these procedural safeguards are decently or fully respected in the current picture of the regulatory systems I am more familiar with. The red ones are with different level of intensity, not sufficiently protected. Each and every one of them would deserve an entire conference, so I can only list here. I cannot dig into the details. But for sure, legality, presumption of innocence is getting better and better. I would say it's getting better in the regulatory field than what is going to be in the criminal law here. That is quite a paradox, if you want. Proportionality, I have a very radical position on proportionality. I think it cannot be considered as an all-encompassing concept. It has to be tailor-made, but still a lot of work to be done when it comes to proportionality. As for the adoption of investigative measures, and with that I want to link with the previous panel, and as for what it concerns the turnover-based system of calculation in terms of final penalty. Separation between investigative and decision-making processes, it varies according to the different institution or agency we are talking about. Public hearing, not a big fan, not going to spend time on that. I think it lost a bit its crucial symbolic value, even in criminal law. Whereas it's very, very pivotal what is the extent of the privilege against self-incrimination in the different regulatory frameworks, as well as the standard of evidence, in particular the moment in which we digitalize so much and we rely so much on artificial intelligence tools, selective tools. The more we are relying on AI-based evidence, the more we need to talk openly about standards of evidence and standards in order to impose a sanction. Where do we stand on some of them? On the nemoteneto sedetegere, the ECHR case law has been quite evolving over time, but I want to be honest, the European Court of Human Rights in general, it's not living the best of its time. So a certain evolution has to be taken into consideration. We had, let's say, the golden age is maybe unfortunately over. So I'm not sure that certain statements will be repeated in the future. Anyway, the right to silence does not cover when it comes to individuals, the refusal to appear or the delaying tactics to any extent. It does apply to direct inculpatory statements when a sanction to individuals for refusing the answer may apply. And this is a direct link, not going back to DB versus Consob, the Court of Justice. This is exactly what the content of the DB versus Consob. When the requested information may be shared with criminal authorities in an ongoing proceeding that is sufficiently closely linked to the administrative one, we cannot impose disclosure of incriminating documents, and this is going to be, I think, a bigger issue, especially in the case of AMLA, maybe less when it comes to banking resolution, but again, not my field. So another very interesting decision is more recent, 22, in the case De Leger versus the Netherlands. I think the court here extrapolated the very content of its approach to the problem, where the use of documentary evidence obtained under threat of penalties in the context of financial law matters is concerned, such use does not fall within the scope of protection of the privilege against self-incrimination. If there are the following conditions, the authorities are able to show that the aim is obtained pre-existing documents of which the authority is already aware it. And I think this is more or less the way out, and I will go back to that in a moment. So what is banned? No fishing expeditions and strict relationship with the existing coercive investigative powers. In order to save time, I think I will skip the description of the Court of Justice case law in the various ORCAM, SGL, Carbon, because I'm pretty much aware all of you are aware of those cases. I prefer to save my time, and I'm coming to the conclusions, about what could be the possible balancing exercise. So, and this also is a way to rejoin the first panel on what are currently your existing investigative powers, because I learned a lot during the first panel. I would propose the following balancing exercise. The more coercive investigative powers are available to the supervisor or to the regulator, the more the nemotenator should be recognized. So we should have a balance between the coerciveness, the intensity, the frequency, and the type, the nature of the investigative power, and the procedural safeguard on the other hand. The less investigative power you have, the more you should be able somehow to obtain what you want from the legal entity at stake. So what could be a possible option would be a solid legal basis identifying the duty to report as the area outside the scope of the nemotenator, because the duty to report for supervisory entities is a field in which we all know those documents, not only we do know that they have it, they know that they have to keep it, they know they have to give it. That area is untouchable for the privilege against self-incrimination when it comes to incriminating documents. Last point, focus on separation between investigative and decision-making powers. This is a structural element that the ECHR imposes on administrative entities endowed with punitive sanctioning powers, as many of your agencies and institutions here in the room. But it's really hard to identify one model in terms of what it means to have a full separation. It's not only a separation of individuals, it's not a different expertise, it's not the lack of, let's say, hierarchical relationship between the different divisions of the same regulator or supervisor. It has to do also a lot with file sharing, in the sense that separation is not only an authoritative separation or power-based separation, it's also a knowledge separation that it's completely, let's say, it's developing in the field of administrative proceedings, but it's a very long road to go. So what is usually the way out of that, saying, well, but, you know, and this is something that Menarini decision of the European Court of Human Rights says very well, but if you have unlimited jurisdiction of a subsequent judicial control, that is enough to solve the problem. And here I'm provocative just to then to dialogue with Miro later on. Something that I think was gone partially undetected is that when Menarini was mentioning unlimited jurisdiction in order to have full judicial control, he meant criminal limb of appeal. And the question is open to all of you, to what extent we do have this sort of control, even with the current amendments in terms of judicial control, especially before the Court of Justice, to what extent we are already there with the independency, with the power to rule on both facts and law, with the power to modify the decision. Because Pinto de Albuquerque dissenting opinion is very clear on that. I am not convinced, together with Pinto, that we cannot recover lost guarantees during the subsequent appeal. And with this, I come to my conclusions. When it comes to punitive sanctions, we need to intervene. There is the urgent need of a legislative intervention, because the case law is completely erratic. Because we have now what we call fairly fair punitive trial that nobody really knows what it is. This is acceptable for the European Court of Human Rights because they intervene only once that everything is over. But this is not useful for you because you need to know on which powers you need to rely. The chair this morning was mentioning the need of bulletproof decisions. That's what you need for the enforcement to be efficient. You cannot be on a sliding surface in which you do not know exactly how slippery that surface is. So, legal uncertainty is bad for the actor, and the legal uncertainty is, of course, bad for the targeted person. It only increases litigation. And especially from what I could understand of banking resolution, you're not using sanctions in order to punish. You want cooperation, and you need to prevent the very detrimental outcome of failure. So you want cooperation, and in order to have that, everybody has to know what to expect. Legal uncertainty in other fields, not in banking supervision or in banking resolution, but in other fields, just led to impunity. If you look at the Volkswagen Dieselgate, this is the outcome. I mean, if you are able to use and manipulate this uncertainty between the black criminal law, the gray punitive, and the white nothing that is finally happened. That finally happened in that case. That's exactly what you have. So, very last, are we sure that a one-size-fits-all approach is what we are looking for? Are we sure that we can cover competition and we can borrow everything from the blueprint of competition and moving it to banking supervision and moving it to banking resolution and moving it, and here I'm suffering, to money laundering and terrorism that are far closer to my heart? My personal answer is definitely no. But again, the time for debate will be very soon. And thank you so much for your attention.
Thank you a lot, Silvia, criminal lawyer on administrative sanctions. Anyway, thank you for this, giving us this theory behind and the grouping and presenting all the relevant cases, etc. So now it's good time to continue, Miro, with your presentation. Thank you.
Well, thank you very much. Good afternoon. Very happy to be here and to share with you in a very rapid way, in a very rushed way, a couple of thoughts about first judicial review and judicial aspects of the sanctioning by the agencies. And as you will notice, we will go a level down from what has been discussed by Silvia, and it will be later on expanded by our colleagues in the panel. What I would like to complete Silvia's provocation with is the mentioning of the Menarini case, in the sense that this is the case that the courts apply or consider to be applying when examining the fines. And with regard to Menarini, it was considered in the specific context of the competition law and the adequacy of the judicial control and judicial protection. So I think this is important to bear in mind, in addition to all the practical aspects that this brings with it. I mentioned the competition law, And the competition law seems to be the inspiration for everything that we are doing or the courts are doing in the other areas, also mentioned by Silvia in her presentation. I wouldn't go as far as to say that to a hammer everything is a nail, but we often behave in such a way. When we have a case, a precedent, it is our case solved. With regard to the judicial review and full, as the European Court of Human Rights calls it, full jurisdiction, unlimited jurisdiction, as the treaty TFEU calls it, and otherwise limited jurisdiction, I would just mention the importance of the fact that there are two different sources, the normal, usual, casual, even if you want, jurisdiction in Article 263 with the 4 grounds of jurisdiction, and then in 261, the full jurisdiction, the unlimited jurisdiction, I'm sorry, that is not provided for in the treaties explicitly, but there is a possibility for the regulations to give the unlimited jurisdiction by the acts of the European Parliament and the Council or the Council in the area of penalties. I'm sorry if I'm stating things that are obvious or maybe even painfully obvious. I'm just trying to prepare the ground for the future discussion. And with regard to how I understand Menarini, the most important element, the most important power of the unlimited jurisdiction that also transpires from the case law that I cite is the possibility for the courts to substitute their own appreciation for the appreciation having been made by the administration. This is something you cannot do. I mean, you can do, but you will immediately be annulled if you do it within the framework of the review of legality of the decisions. So substituting the possibility to substitute your own appreciation to the one of the administration. And as I mentioned, the application of the principles and the rules adopted or developed within the framework of the competition law, I should probably also mention that in the area of supervision, those principles were expressis verbis, also confirmed in the first cases in which the General Court decided in 2020, which were the VQ and Crédit Agricole. We can discuss those cases a little bit later on. Now, the agencies. And I would really like to have your attention in the sense that we are now discussing something that is not commonly discussed, as we will see in the future. We have the institutions, and in the context of the institutional case law, the things are more or less clear. What is clear with regard to the agencies and their sanctioning powers is mostly the fact that we are united in diversity, and there's a lot of diversity in the area of the sanctioning power of the agencies. Some of the colleagues, like me, participate in the various networks of the agencies, like the boards of appeals and so on, and we have discussed very important issues of organization, management, financing, and similar. But unless my memory fails me dramatically, we have never discussed the question of sanctioning by the agencies. That question simply wasn't relevant, or not yet. So it's a great opportunity to be here today discussing this subject that will very probably become very important in a very short time. With regard to the agency and the delegated powers, I would still again risk to say the obvious. Nothing on delegation to the agencies, and as there is nothing in general, there cannot be anything specifically with the sanctions in the treaties, which is then counterbalanced by the fact that there is the acts of the agencies, bodies and offices are included among the acts that can be, whose legality can be reviewed and they can be annulled if they intend to create legal effects vis-à-vis third persons. The other counterbalancing element is the case law of the court on the ESMA short selling case, which basically upgraded the Meroni doctrine and made it fit for the area of artificial intelligence in which we are living today. Finally, with regard to the common approach, do we have it? Well, with the words of a famous Belgian comedian, yes and no, in the sense that there is a document that is called Common Approach to EU Agencies, dating to 2012, and that contains a blueprint. It is formally a communication by the European institutions. It is a blueprint for what the agencies and their organizational aspects should contain and how they should be organized, managed, and so on. Nothing on sanctions. You will not be surprised to hear that probably it was too early to contemplate such a possibility for the future, but that future has now become a reality. I would like to spend the last couple of minutes on a short presentation, short comparison, comparative reading of 3 different regulations. The first one is the ACER remit regulation, and you will ask yourself probably, you are asking yourselves, why ACER, Agency for Cooperation of Energy Regulators? What do they have to do with the sanctions and financial services? But ACER does have something with financial services, because this is the agency that is also responsible for the market integrity and transparency in the wholesale markets of electricity, natural gas, and from last year, hydrogen. And it needs to take care, according to the rules developed within the financial sector, of the integrity and transparency of those markets, also with running the registers on insider dealings, insider trading, market manipulations, and similar. So in that context, we are approaching the ESMA in a certain regard. The other reason why I chose it was because it is relatively recent. It was adopted last year. And now the preparations are underway for its implementation. AMLA, it's a natural candidate, adopted last year, entered into force. Now the majority of provisions will start to apply from 1st of July of this year, and then until the end of the year, the whole of the regulation will apply. And I thought AMLA regulation is the one, as it is the most recent, that contains the state-of-the-art of legislation, regulation, and all the applicable case law. I think that Silvia has certain doubts about it, me too. And then I don't know why I chose SRB founding regulation, but there it is, there it is. And I would like to mention just a couple of elements in those 3 regulations where the differences seem to be important to my mind. The first one is pretty typical. The authority of the agencies to conduct general investigations, on-site inspections, announced, non-announced, taking statements, requesting documents, requesting information, and so on. Imposed by a decision, and against that decision, there is normally, I say normally, an appeal, a review possible before the appeal body. In the case of ACER, it's a Board of Appeal. In the case of AMLA, it's the Administrative Board of Review, not to be confused with the Administrative Board of Review of ECB, because the nature and the powers of these 2 bodies are different. And finally, the appeal panel in the context of SRB. The interesting thing, both with regard to the decisions ordering an inspection, for instance, as well as decisions imposing a sanction a sanction, is that within the context of ACER, those appeals against those decisions or requests for review do not go to ACER Board of Appeal, but they go directly to the Court of Justice of the European Union, while in the 2 other cases, they first go to the appellate body, and then eventually to the Court of Justice. So this is one important difference in my mind. Then with regard to periodic penalty payments, for ACER, this is the one and only possibility to have something similar like a penalty imposed on a party, to try to get them to do whatever ACER is trying to achieve. For the other 2 agencies, and there are also other agencies that have sanctioning powers, for the other agencies, it is more, they have more instruments at their disposal, fines, periodic penalty payments as well. But the interesting thing, and here I come to the discussion that Silvia started, in AMLA regulation, it is explicitly provided that AMLA may impose periodic penalty payments with retroactive effect. So what does this make out of these periodic penalty payments, if not the fines or not the penalties, properly speaking? This is one of the things that surprised me as not being a criminal lawyer when reading those regulations. And then maybe the last words about the unlimited jurisdiction. I couldn't believe my eyes when I read, in the 2 regulations out of the 3 analyzed. I wanted to analyze all the regulations establishing the agencies, but then I wouldn't finish before the SRB Legal Conference 2027 or something like that. So I limited myself. And I was surprised to see in 2 of those regulations that they confer to the Court of Justice the unlimited jurisdiction, meaning that the Court of Justice may annul, reduce or increase the penalties, fine or penalty payment. There is one regulation that doesn't have that provision. This is the SRB regulation, as I call it. Is that a problem? I do not know, or I do not know yet. It remains to be seen. But it is an interesting thing, so interesting that I couldn't believe my ears, literally. So I asked the second and the third opinion of Matteo and Tim, who graciously confirmed that I'm right in not seeing it. Then to finish with the presentation, I would just say that the more important or the most important things happen when the 2 legal systems meet, the European Union and the national systems. One of the important discussions taking place right now is we are, let's say, doing everything we can for 3 months. We develop and distribute the investigation report. We give it to the national authorities. And we want it to be useful and used. Can we have it or not is a question that has to be asked to the national authorities very often. The next question is availability of resources. We said, it was developed within the context of the competition law. There are many differences with the situation at the agencies, who very often do not have the resources at their disposal to run everything the way the Commission would do it, and who also don't show much willingness to collaborate on these important issues. And what is next? I would like to believe that what is next is what is mentioned in Article 29 of AMLA regulation and this common culture of sanctioning. It is also mentioned in Amandine's general report on sanctioning. So practice will tell. And I would like to thank you for your attention and really for a timely possibility to discuss these important questions that risk to become a reality very soon. Thank you very much.
Thank you, Miro, for this excellent contribution. You have done a lot of work to compare also different powers of different agencies. It's very valuable for us at SRB, especially now. When we have not yet practiced our sanctioning powers. Very interesting findings, but in the interest of time, we need to continue. So now it's Amandine, it's your turn. Yeah. Sorry. Did we agree that Roberto is first? So I was, yeah. All right. Okay.
Okay, so good morning. I'm very happy to be with you today for the SRB Legal Conference. I feel a bit like Silvia as an outsider because I'm not from the banking sphere, so I will maybe use some jargon, but not the banking jargon. I was invited to provide you with my expertise, my experience on the enforcement, ESMA enforcement powers in the last years. I will try to give you some practical insight on our work. So first, to start my presentation, for those of you who are not very familiar with ESMA, ESMA was established at the same time as EBA and EIOPA. But the main difference is that that was the first and for a long time the only European supervisory authorities with direct supervision and enforcement powers. This has changed recently with MiCA giving some enforcement powers also to EBA, based in fact on a model which is very similar to the one that ESMA has tested for more than a decade. So at least from my side, I see it as a good sign that we managed to establish ESMA as a credible enforcer. On this slide, you will see that ESMA is tasked with the direct supervision and enforcement of several different entities. You will see the credit rating agency, of course, since 2011, the trade repositories since 2012, and more recent supervised entities, such as certain data reporting service providers or Tier 2 CCPs. So those powers were conferred to ESMA with the aim of ensuring the level playing field and also trying to eliminate regulatory arbitrage. As you can see, mainly the power were conferred to ESMA on entities which were newly created, such as trade repositories, or newly supervised, such as CRA when ESMA received the mandate, or on some entities having an EU dimension. What you can see also on the slide, and that's maybe something where I want to provide more figures, not to enter too much into the theoretical debate, but to provide more figures on what we have done so far. So since 2014, there have been 20 enforcement actions, sometimes leading to multiple decisions in case multiple players were sanctioned within the same case. As you can see, most of the sanctions were imposed on credit rating agency, more than 80% on CRAs, and the rest on trade repositories. So far, no sanctions have been imposed on the entity that have recently come within ESMA supervisory remit. This is normal because there is usually a time gap between the application of new rules and enforcement, and we see it also at national level. Now I would try to briefly summarize the enforcement process at ESMA. It's a very structured procedure for legal reasons, so we are really bound by the boundaries of the very specific legal framework which apply to us. In particular, there is, as mentioned by Silvia, the importance of a clear separation between investigation and decision-making. And you see it on this slide with, if we start from the left, you will see that there is first the investigation by the supervisors. And when they identify potential breaches, the matter is referred to an independent investigating officer. So this is what we call IIO. So this is where I start using some jargon. And this person is really tasked with the investigation of potential breaches and also has very strong investigatory powers. So he can request information, he can go on site. So exactly the same kind of powers that supervisor will use during supervision. So this person is a key actor in the enforcement process. This person will be tasked with the drafting of a statement of findings. Will receive comment from the person subject to investigation, and will submit his file to the Board of Supervisors, which is ESMA decision-making body. I want also to focus on the procedural safeguards. So, as we mentioned before, we need to be sure that our ESMA enforcement decision will be legally robust, and the legislation clearly identify a lot of conditions to be met by ESMA before being able to impose a sanction. So in particular, regarding the independent investigating officer, you will see on the slide a lot of conditions. The first one is that, in particular, this person must not be or must not have been involved in the direct or indirect supervision or registration of the person subject to investigation. So this separation is important. At the same time, it's quite difficult to put this in place in relatively small organization because you would like to be able to benefit from the experience of supervisors on this specific industry. But this is, in a way, quite limited because of this legal constraint. Then another important point is that the IIO must perform his or her function independently from the board and from ESMA. So it means that the person will really work independently, will not receive order or not receive order from the hierarchy, for example, or from supervisors. He will have to be really independent and impartial between the supervision and the board of supervisors. It also means that this person will assess inculpatory and exculpatory evidence, so being sometime in the position to drop some serious indication of breaches, so which might also mean that supervisors might not be always very happy because of this, but that's his role to perform his investigation independently. And a last point, very important, is that this person must not participate in the deliberation of the decision-making body and must not intervene. So we have taken this very strictly, so the IIO cannot go and present before the board. He just sent his file, and then there are no further interaction, which is good from a legal point of view. In practice might be also difficult because you're losing some knowledge, and then board members might have some question and they cannot be directly addressed by the IIO, who has already spent a lot of time working on the file. In practice, the IIO would be an experienced lawyer in the enforcement unit, and despite the clear separation, this person will still be able to ask questions to supervisors if needed, but then all those interactions will be recorded in the file to ensure the right of defense of the person subject to investigation. Then on the person subject to investigation, there are also clear legal conditions which are mentioned in the legislation. So there are two rounds of comments. One is the right to be heard before the independent investigating officer, and then this person will have a second round of comments before the board of supervisors. So as you can imagine, it makes the process quite long, quite heavy and burdensome, but this is also because of the right of defense. This person also has the right to request access to the file, the right to be supported by a legal counsel. So all those points which were also identified by Silvia in her presentation. What I want to highlight is that the right of defense is mainly through written comment. In theory, there could be oral hearing before the board of supervisors, but this has never taken place because in practice, all the exchange are taking place in written. On the next slide, you will see the outcome of the enforcement procedure. So based on the file submitted by the independent investigating officer and following the right to be heard, the board of supervisors will take the final decision on the sanction. So first, the board will decide whether a breach was committed, and then the board will decide the sanction which should be imposed. So it's important for effectiveness that the best tool is selected based on the impact and seriousness of the breach. In practice, this can range from the public notice to the withdrawal of registration to a fine, also in case of credit rating to the suspension of the use for regulatory purposes of those credit rating. In practice, what we have seen so far is that the Board of Supervisors impose, in all cases, a public notice. And when negligence or intent is established, there is also an obligation to impose a fine. In this respect, you can see on the right the amount of the fine imposed so far. So we have imposed more than 17 million euros. So maybe quite low compared to competition law, but still in our area, this is quite relatively significant, I would say. Regarding the amount of the fine, there is not so much discretion in the calculation of the amount. Some newer regulations are based on turnover. However, for the CRA regulation and EMIR, which are the area where we have imposed so far all our sanctions, there is a very precise indication in the legislation of the basic amount, of the list of aggravating and mitigating factors, and of the coefficient. So at the end, it's mainly an arithmetic calculation without much discretion. So maybe it's good for the Meroni doctrine, then maybe for the proportionality point of view, it's a bit more complicated, because the proportionality is supposed to be built, embedded in the legislation. But in practice, we can see big difference in the size of the entity. For example, CRAs, we have big four, and then even middle-sized CRA would receive the same kind of level of fine as a big four. Maybe another point to mention, and I think that will be also addressed by the in the next presentation, is that we have the right to impose periodic penalty payments, but so far we have never done it. What we have seen is that supervised entity usually take remedial action before the end of the enforcement procedure, making the use of PPP a bit less relevant in our case. Regarding the publication, I think that's an important point that I want to highlight. There is in the legislation the obligation to disclose to the public every fine and periodic penalty payment, but we also decided for transparency reason to publish the full content of our sanction decision. Of course, we redact personal data, we redact business secrets, but all the rest, all the details of the findings are published on our website. For us, the reason is twofold. First, we have seen that in some cases, the reputation risk for the entity is more important than the precise amount of the fine. So that's why publication is important. And also to ensure credible deterrence, we think that it's important to make sure that the market and the other supervised entities are well aware of their obligation and ESMA interpretation of the different requirements. Then I want to spend a bit of time on the review by the Board of Appeal. So when we are mentioning the Board of Appeal, in our case, it's a joint Board of Appeal with EBA and EIOPA. So far, ESMA enforcement decisions have been tested twice before the Board of Appeal, but never before the General Court. Which seems to show that supervised entities generally accept ESMA's stance when they are sanctioned. And regarding the two cases that I mentioned, so one is on the Nordic banks, 2019, and the other one is on scope rating, which is a medium-sized CRA, 2020. So the picture of those appeals is a bit mixed, because in the first one, the Board of Appeal decided to remit the decision to ESMA, which means that we lost in some aspects, whereas in the second case, the Board of Appeal upheld a completely ESMA decision. So in the first one, what is important is that the picture is mixed, because on one side, the Board of Appeal accepted and validated the test of negligence, the concept of negligence that ESMA has used so far, which is trying to affirming a very high standard of care, which is required from credit rating agency and other financial service providers. And also referring to previous case law in competition, as we mentioned also before. However, in practice, the Board of Appeal decided that there were very specific factual circumstances in the case, and that there was no negligence, and therefore no fine could be imposed. It's important here to say that, in fact, the IIO, the Independent Investigating Officer, had the same view at the Board of Appeal. So you see as well that it plays a key role, and that the Board of Appeal also rely on the fact that the Board of Supervisors did not follow the IIO on this point, and decided to remit the decision to ESMA in this respect. Otherwise, on the other aspect, the Board of Appeal sided with ESMA on the existence of the breach, which were related to the fact that 4 Nordic banks were issuing credit rating without being registered under the CRA regulation, and also decided for procedural efficiency to handle those cases together with only one oral hearing, and also on the good aspect, positive aspect from ESMA side, a suspension request was denied. So that was in line also with the Court of Justice case law on the suspension request. In the second case, the scope rating decision, once again, the negligence was a key aspect which was discussed, and the Board of Appeal re-emphasized the high standard of care which is expected. Then the principle of proportionality was also discussed, because, as I said before, it's something which is very often discussed by the entities which are subject to a fine, because they consider that this limited discretion of ESMA does not allow ESMA to really calibrate the fine to the turnover or to the size of the entity, and also to the importance of the breach. However, here the Board of Appeal recognized that ESMA does not have a margin does not have a discretion to calibrate the fine, and has to apply the legislation as it is provided regarding for the calculation of the fine. Then the Board of Appeal also recognized the ESMA margin of appreciation as a specialist regulator, so for the interpretation of the breaches, and limited its review to whether the Board of Supervisors comply with the procedural rules, so very important, with the duty to state reason, and did not commit a manifest error of appreciation. I will now conclude my presentation. So ESMA has been an enforcer for over a decade, and the process can be considered as relatively robust. Even so, I think it's also the right time maybe to think about potential improvement. So there is a point on proportionality that I mentioned, where maybe giving more discretion to ESMA to set and calibrate the amount of the fine would be a good proposal. I want also to mention that in terms of procedural consideration, would be very useful if ESMA could be able to adopt sanction via a settlement procedure. I think that would expedite the process for everyone, the authority, but also the party. So also in line with the simplification discussion we had this morning. And finally, last word, I would just like to mention that we are publishing every year a report on the sanctions which are adopted in financial market at national level. So here we are really talking about all the national competent authorities imposing sanctions, for example, under market abuse regulation, MiFID, EMIR, etc. So I've put a screenshot of the snapshot of last year, but this October we will publish a new version of the report with updated figures. And I think it's very important to enhance the transparency on sanction in financial market, but also to make sure that we're trying to converge on enforcement, as Miro mentioned, trying to ensure a common culture of enforcement. Thank you.
Thank you, Amandine, for your valuable contribution and for this presenting us the enforcement practice at ESMA. So now we will hear what is the practice at the SSM ECB side. Welcome, and the floor is yours, Roberto.
So thank you very much, and let me start by thanking the colleagues in the SRB for the kind invitation to participate here. It's my great pleasure to share the experience of the ECB in the field of sanctions. I'm the last in the queue, which is always something with positive aspects and negative aspects. On the positive side, many things have been said already, so I can skip them and refer to the previous speakers, the distinguished panelists today. But the bad thing is that the buffer of time that we had at the beginning of this panel has been more or less exhausted. So I really need to be disciplined with the time, so not to stand in your way to the lunch. So without further ado, in the ECB experience in the field of sanctions, let me see if I know how this works. Okay, so I'm going to make a short introduction, and then the focus of my intervention will be on the sanctioning powers of the ECB in the field of banking supervision, and I will also make reference to the experience that we are making, as we speak actually, in the context of periodic penalty payments. So, first of all, as a reminder, the ECB combines both the monetary policy function and the supervisory function, and these two functions have distinct sanctioning powers, as we will see in a minute. So, let me just say very few words on the monetary policy side, and then to zoom in the banking supervision side. So the possibility for the ECB to impose sanctions on undertakings was already foresawn in the treaty, in the statute of the European Central Bank, and was enacted through the Council Regulation 2532 of 1998. So this regulation foresaw already the possibility for the ECB to impose sanctions and periodic penalty payments in case of infringements of ECB regulations or ECB decisions. The Council regulation contains as well some procedural rules, mainly described in the slide. So the proceedings are initiated by means of an infringement, of a notification of the infringement, of the initiation of the infringement proceedings. There is right to be heard for the undertaking. Then the executive board adopts the sanction, and there is right to for the sanction institution to request a review by the governing council. The upper limit of these sanctions in the monetary policy side is quite modest compared to what we will see in a minute later. Is up to 500,000 euros, and there is also rules about the limitation period, which runs from 1 year since the facts are known to the ECB up to 5 years since the relevant facts took place. In practical terms, we have applied sanctions in the field of monetary policy in the area of enforcing the rules on minimum reserves, so the minimum reserves requirements when they were breached, we have imposed sanctions for those breaches, and also in the field of statistical reporting requirements. But as I said, the focus today will be more on banking supervision. So the picture that I just outlined for monetary policy was broadened when the ECB was also granted responsibilities over banking supervision in the context of the single supervisory mechanism. So Regulation 1024 of 2013 conferring specific powers and responsibility of the ECB also granted specific sanctioning powers in this area. I want to move on, and then I will go back to the details that are in the previous slide, just to outline the scope of sanctioning powers that are foreseen in the context of the SSM regulation. So firstly, the ECB may impose sanctions, administrative pecuniary penalties on significant supervised institutions, what we call SIs, for breaches of directly applicable EU law. This is paragraph 1 of the Article 18 of SSM regulation. But in other cases, the ECB may instruct NCAs in the context of our responsibilities in the SSM, in the single supervisory mechanism, for those to initiate sanctioning proceedings for breaches, for other breaches, meaning mainly breaches of national law, transposing EU directives, but also national law, conferring specific powers to NCAs that are considered to be necessary for the ECB to discharge these tasks in the context of banking supervision. Just to note that this option was used in 2024, so last year, and led to the opening of 24 sanctioning proceedings at national level by NCAs at the request of the ECB. And finally, there is a reminder or a cross-reference in paragraph 7 of Article 18, reminding the possibility for the ECB to impose sanctions and periodic penalty payments under the Council regulation that I mentioned before, Council Regulation 2532 of 98, for failure to comply with ECB regulations or decisions. So this is the scope of sanctions, mainly the ECB directly responsible for sanctions, for sanctioning breaches of directly applicable EU law. And then with the ECB being, having the possibility to request the initiation of sanctioning proceedings to NCAs for breaches of national law. So going back to the previous slide, some procedural rules. So I will not spend a lot of time here in the interest of time, but very similar to what we learned before from our colleagues in ESMA. So we have also created or imposed a separation between the investigation phase and the decision-making phase. And there, the investigation will be conducted by what we call, different acronym here, independent investigating unit. There is, of course, right to make submissions to the independent investigation unit on the factual outcome of the investigation and all the objections that are raised and that are communicated through the notification of what we call the statement of objections. And there, the decision-making process, which involves, in our case, because of the structure that we have in the SSM regulation, the supervisory board adopting the draft proposal, and then the final adoption by the non-objection procedure with the involvement of the governing council of the ECB. In the case of banking supervision, the limits, quantitative limits for sanctions are higher, much higher. Actually, we go to the famous turnover yardstick, and in this case is 10% the limit for the annual turnover that sets out the upper limit for our sanctioning powers in this field. I have to say that, as previous speakers, the annual turnover as an indicator is not the best one in terms of proportionality, because it may lead to disproportionate results. And this is why, in our experience, what we mainly do is we use it as a cap, but within this cap, we also consider other parameters that, in our view, are more conducive to be proportionate in the final amount. In particular, is in our understanding, the size of the institution is more relevant in this context, because the annual turnover is a figure that actually may have enormous fluctuations from one year to the other, and it doesn't reflect properly the financial strength of the institution, which is the one of the parameters that, in our view, should be considered in this context. About the limitation period, this is 5 years since the relevant facts took place. And just to give you a very quick overview of the practical application of this framework, last year, 182 administrative penalties were imposed, but this figure, I have to put it into context, because this is the figure for the whole SSM, and it includes then sanctions imposed also at national level by NCAs. And actually, NCAs, I have to admit, in this context, they are the biggest contributor to the sanctioning action of the SSM, because in the ECB itself imposed much less sanctions. Also, you saw in my previous slide that the scope for our action is more limited in that regard. So, of all those sanctions, mainly where the bulk goes to pecuniary penalties, fines, totaling an amount of circa 28 million last year. And if I were to allocate this between the different areas of banking supervision, so the Oscar would go in that context to breaches in the area of internal governance, with more than half of the sanctioning proceedings relating to breaches in the context of internal governance requirement. And as you know, internal governance requirements are set out in the CRD, not in CRR, which means that in this context we are not directly competent, and we need to refer the matter to NCAs through the mechanism foreseen in Article 18.5 of the SSM regulation. Apart from internal governance, we also impose sanctions in the field of reporting large exposures or capital requirements and qualifying holdings. Then, perhaps this as a quick and very high-level overview of the ECB experience in the field of fines, pecuniary penalties. But let me spend also some minutes in perhaps the area of less known area of periodic penalty payments. Periodic penalty payments are amounts that become due in the case of an ongoing infringement of an ECB decision or regulation, and until the undertaking restore compliance with the breach obligation, with a limitation of 6 months. This is the maximum period for which they may run, but in the meantime, until full compliance is restored, they are accruing. And perhaps interestingly, I can say also a few words about how we use in practice periodic penalty payments, PPPs. So the main legal framework is, as I said before, Article 18.7 of the SSM regulation, but actually there is more a cross-reference to the provisions in the Council regulation of 1998, which already foresaw the possibility of periodic penalty payments being imposed by the ECB. In terms of procedural rules, here we conceive periodic penalty payments as measures distinct or not having punitive nature, and this is why we apply due process, but we don't apply the strict separation in between investigation and decision making as we do for the other sanctions that are imposed or the other enforcement measures in the form of fines. The upper limit here is lower, is 5%, but this is daily turnover, not annual turnover, because by definition, PPPs accrued per day, and this is the way we impose them. And as I said before, they can be running for a period maximum of 6 months, because then it stops from running and we need to put an end, even if the breach is still ongoing. So as decisions of the ECB are reviewable acts when we impose PPPs, and interestingly here, the Council regulation of 1998 explicitly acknowledge unlimited jurisdiction of the court, so that it may adjust even the amount of the penalty. I said interestingly because it's not said anything about the other sanctions that I mentioned before in the SSM regulation. It's only mentioned here in the context of the Council regulation of 18.8, and then of course it raises the question what about the other type of sanctions that we talked before. We have developed two main procedural avenues or pathways, if you can call them this way, to impose periodic penalty payments. What we call the standalone procedure, which is the procedure by default, the one that we use normally, and it consists mainly of 3 big procedural steps or 3 decisions. The first one is the ECB decision, which imposes obligations and deadlines. This is the decision on the substance. Then this is the one that is not complied with and leads, or when it is not complied with, may lead to the imposition of periodic penalty payments to restore compliance or to ensure compliance, which is the second step. And then when compliance is restored or after 6 months, the overall amount accrued is fixed in the final decision that is taken in the third place. But we have also devised for a more expedient way of imposing PPPs what we call the combined procedure, in which the 2 first steps are merged in one, and then the PPP's accrual is made dependent on the existence of a breach of the underlying obligation that is imposed in the same decision. So why to use PPPs? Perhaps a few words there, and then I will be finishing. So the issue is that what we have realized is that there is perhaps a gap to be filled or to be breached between what we can achieve through the normal supervisory dialogue with institutions and deterrence with sanctions that may come later. And this gap in the middle is when we see an ongoing breach that is still there, and we need to make sure that it is timely remediated. And this timely issue is perhaps the key word in the context of PPPs. The PPPs are mainly used in this context to ensure timely remediation of ongoing breaches of prudential requirements. So just very quickly as well, we have made use of this instrument in the context of our work on climate and environmental and nature-related risks. And precisely with this idea of ensuring timely correction or compliance with prudential requirements. We started our discussions with banks in this context in 2019, but despite the different steps that we took in the context of supervisory dialogue with thematic reviews, stress tests, operational letters with feedback from the supervisory teams, we didn't see the level of improvement that we were expecting, in particular when it comes to the materiality assessment of the impact that climate and environmental related events may have in the traditional risk drivers for banks. And this is why in some cases some banks have received what we call combined decisions, in which we impose binding requirements and also threaten them with the possibility of potential imposition of PPPs in case of lack of compliance. So I think, and with that I will be concluding, the case for PPPs is getting traction in the sense that also the events that took place in March 2023 as a lesson tell us that it's not only about good assessment and good analysis by supervisors, but also about being effective in when it comes to ensuring that supervisory requirements or prudential requirements rather are complied with, and then in cases of breaches, those requirements, the compliance with those requirements is timely restored. And this is why, in my view, PPPs are here to stay with us and will be used probably more and more because of what I said before. This tool facilitates the bridge of this gap between supervisory dialogue and final deterrence in the context of sanctions. And as a final word, enforcement, in our understanding from the ECB perspective, should not be seen as something separate from supervision, but another tool available for supervisors in terms of our supervisory toolkit. And we will make sure that we are as effective as we want to be in our supervisory activity, and we achieve the intended outcomes also through making use of this tool, which is has been made available to us by the legislator. And let me conclude there, and happy to take questions. Thank you.
So many thanks, you, Roberto, for the comprehensive presentation of ECB's enforcement practice. So I think after these presentations, we have now a quite rich understanding on the enforcement topics are in EU financial services area. And in the interest of time, I want to jump immediately to the questions from the audience. And perhaps somebody in this room here at the SRB wants to start. Is anybody else than Jaakko interested? I mean, yes, okay, Jaakko starts, and at least two other hands were seen. Jaakko.
Thank you. It was really, really mind-blowing to listen to this. I would jump into this discussion on the proportionality. Just can you clarify your point that why do you see that linking the penalty payments to turnover is not proportionate? I mean, intuitively, you could think that actually that is very proportionate. And I understand there could be better metrics. I think ECB was alluding towards that, but still, would it be balance sheet? But that may have fluctuations as well. So there might not be perfect metrics. But what's the issue with the percentages?
Who wants to react first? Yes, Roberto, perhaps.
Well, in our view, the issue is mainly driven by, firstly, the fluctuation, and the fluctuation is higher in our view in the turnover compared to, for instance, the size, which also may fluctuate over time, but not to the same scale as the turnover on the one hand. Also because what we see is that turnover may lead to the same fines being imposed to institutions of very different size. And in our view, this may not ensure a complete proportionate reply, because you can have firms of different size with the same turnover. So then if you apply only turnover and you disregard other aspects of, so because in the end what we want to capture here is to make sure that the sanction is deterrent and persuasive enough compared to the financial strength of the institution, because the deterrent effect individually considered is when we are able to influence the behavior, the future behavior of the bank, so that the bank will think twice next time before not complying with prudential requirements. So this link with the financial strength, in our view, is better captured if you look and consider more parameters than just turnover, because of annual fluctuations on the one hand, and also because of the fact that it may result, so one institution could be very profitable one year just because of one-offs that happened that year, and it would not be so, in our view, proportionate in the sense of ensuring proper deterrence going forward if you disregard other parameters like the size of the institution, which in our view captures better this aspect. But this is for sure what
Thank you for sharing your
developed.
thinking. And Silvia, you want to say something?
Thank you very much. It's really hard to condensate in one sentence, but my analysis on proportionality starts from the point of view that there is a gray area of punitive proportionality that is in between. So the administrative proportionality, it's usually only meant to be efficient and effective toward the single legal entity we identified. Whereas in the gray zone, we have to, let's say, consider what we consider criminal proportionality, in which the equality principle plays a pivotal role. Meaning we have, usually in criminal proportionality, we have the ordinal and the cardinal proportionality. So you have to compare the seriousness of the offense not only within itself, but also in relation to the other offenses. And this is something that is maybe for the future to be discussed. And I'm very much relieved that Roberto gave a much more solid explanation why it also creates a problem within ordinal proportionality. Because you do not want, especially thinking about the seat we are, the SRB, you do not want the final event to be aggravated by your sanction. That is not in your interest. So considering the fluctuations and considering that you might end up aggravating the financial position of the entity. And then, if I may add, for future debate, consider that we are now giving this tool to criminal judges, and I am scared, enormously scared of the potential outcomes.
Okay, did you, Frank, want to react on this or no? You don't have the speaker now and nobody doesn't hear. There's a lot of hands raised and I was told that we need to finish because we have used our time. So, but you do. Yeah.
Just one remark here. We talk a lot about the how high these amounts could be, what is proportionate, etc. But I've noticed that in the end, what banks what moves banks is not the amount at all. They don't really care whether they pay 500,000, 20 million, 10 million, especially for the big banks. Many of these fines are lower than the highest bonuses in a year that are being paid to, I don't know, the 10 biggest banks. They don't care. They care about one thing. Publication.
Yes,
yeah,
naming it.
transparent.
So I wonder whether we should not be talking a lot more about that, because in the end, that is what moves them.
Okay, thank you. So one question: who was there raising your lady with the white lady?
Just as a very
please present. Who are you?
Von Ballen-Welles law firm. So just as a very quick follow-up to the proportionality. So why would you think it would go differently here than in competition law? The 10% that is not seen in your view as proportional.
In my humble view, but again, I'm not the expert on banking resolution. It's because the punitive character is higher in competition law than here. Here you do not want that much. You want more cooperation in order to prevent failure. But I'm maybe the less expert among the panelists. So
yeah, I think it was a very good answer. Unfortunately, now we need to finish because we have the lunch break and the third panel, and we missed the discussion. But anyway, you had the chance to present your viewpoints. Or Miro, you look that you want to say something.
No, I'm fine.
After listening everything, what was the thing which you wanted to react?
Everything was perfect. Nothing to add.
Okay. Okay, thank you. So, I think it was very excellent and inspiring. Well, it was not a dialogue, it was a panel, presentation, a group of presentations. Unfortunately, we don't have time for the discussion. But anyway, I'm pretty sure that this will inspire us for further cooperation between agencies, and you took up many topics that certainly we need to work on more. So many thanks for all the panelists. Thank you.
And indeed, thank you very much, Tuija, and all the panelists. I think this discussion continue over lunch now. For those of you here within Brussels, please join us outside the room, and we will reconvene for the third panel at 2:15. See you then.